Okay, Chapter 5, Part 9. And we're talking now about expert witnesses. This may not be Part 9, excuse me. This should be Part 11, expert witnesses. Okay, so an expert is a person who has specialized knowledge due to their education, training, skill, or experience. Experts, as opposed to lay people, are allowed to offer their opinions and conclusions about the evidence. In addition, they can make those opinions or conclusions based upon things that they have learned from reliable sources of evidence that have been introduced in the case, not necessarily from their personal knowledge. So they can testify, from example, a doctor could testify based upon medical records, their opinion about something, even though they may have never seen the patient. Okay, now, bullet number 3, very important. The Frye test versus the Daubert test. Okay, for many, many years, both the federal courts and most states, including Georgia, used the Frye test to determine whether or not somebody was an expert and could testify about something in a case. It was a very broad test. Basically, all you had to do was show that you met this criteria and that what you were testifying to was going to be helpful to some issue in the case to the jury. It led to what we became known as junk science, so that there were things being admitted into courts that most people, and especially legal scholars, didn't think were appropriate. Eventually, about 10-15 years ago, the U.S. Supreme Court, in the case called Daubert versus Dow Chemical, said we're no longer going to use the Frye test in the federal system. We're going to use a new test. Okay, and most states have adopted that new test, the Daubert test, including Georgia. So the Daubert test says that the judge, first of all, under Rule 702 of the federal rules, is the gatekeeper of such evidence. The judge has to be more aggressive and take more control over determining whether somebody should be able to testify as a expert witness. The testimony that the expert's offering has to be relevant and reliable. It has to be based on scientific knowledge, and that scientific knowledge has to have used scientific methodology. Okay, and that it has been tested in the scientific community, that the error rate is known and that the error rate is acceptable. And so you can look at all these 6 factors here. So now it is not as easy to get something in terms of an expert unless you meet the Daubert test. So let me give you a scenario that would kind of explain this as an example. All right, so some of you may remember the Casey Anthony case down in Florida, maybe 8 or 10 years ago now, where Casey Anthony was accused of killing her daughter. And in that case, the prosecution had questioned Casey's mother, and Casey's mother said that she had lent her car to Casey. Casey was going somewhere with the daughter, the granddaughter, and when she got the car back, she opened the trunk, and it smelled like a dead body had been in the trunk. The prosecution located a group of scientists at a university in Tennessee who had been studying the possibility of determining what object was emanating odors in a contained area. And they believed that they could tell whether or not the air in that trunk has the air of a decomposing body. Okay, so under the Frye test, the judge probably would have allowed them to testify based upon the fact that they claimed to have science, etc. They were experts, etc. On the Daubert test, they would have never made it. Still was new. It had not been tested. You didn't know what the error rate was, etc. So that's an example of how Daubert has kind of clamped down on expert testimony. Okay, so we're going to stop there and we'll pick up with part 12.